In this lecture, we would like to discuss the most important global issue concerning every human being, animals, plants in every corner of the world, and that is environmental pollution. And regarding environmental pollution, the Stockholm International Environment Commission and the summit and its results and the Rio de Janeiro conference of 1992 on Earth Summit, and combinedly these international documents and the General Assembly of United Nations organizations appointed the Broadland Commission under the chairmanship of former Chancellor of West Germany, Dr. William Broadland, in 1983, and he submitted its report in 1987. And this report of Broadland and the international documents, they spelled out certain important and vital principles, of which we found one of the most important principle is the polluter pays principle. So what exactly this polluter pays principle, that we would like to discuss. So before that, we would make an introduction about environment and the very need of applying this principle. So there are two sides to every coin. So are the pros and cons of the Industrial Revolution. On one hand, the Industrial Revolution has improved the lives of people in many ways in the 21st century. On the other hand, unfortunately, the Industrial Revolution has caused industrial pollution. Technology has developed drastically, and manufactured products have replaced the traditional products. The byproducts are the inevitable part of the manufacturing process. Hence, principles such as precautionary principle and polluter pays principles are constitutional mandates to curb the degradation of the environment. Therefore, it is no barrier for a citizen to be aware of the principle of environmental law. In certain cases, the impacts of the industrial disaster are said to be experienced till death. Take for the instance the incident of the Bhopal gas leak. The pollutants which shipped into the groundwater years ago still forms the reason for cancer, growth retardation, let alone the immediate impact of the leakage. The deadly methyl isocyanate which drifted. Also, the sleeping city caused the death of thousands of inhabitants within a few days. Such incidents in the past further necessitated mandating principles for combating the effects of pollution. high amounts of pollutants emitted by the vehicles put forth the question whether the owner or the manufacturer will be liable for the pollutants emitted. The scope and extent of the polluter pays principle is explained in this lecture. So now we'll discuss about what is this principle. That is the polluter pays principle. So the very principle essentially holds the polluter liable for the pollution caused by the environment. So the polluter is liable for every damage caused to the environment. So, according to polluter pays principle, the polluter has to not only compensate the victims of pollution but also compensate for the restoration of environmental degradation caused as under 1972 and 1974 Organization of Economic Cooperation and Development. The measures to be taken by the polluter for controlling the pollution is decided by public authorities so that the environment is in acceptable state post the industrial operation. Therefore, the polluter bears the cost of health hazard cost to the public as well as the cost of restoration of the environment. In other words, the cost of the measure should reflect on the cost of the goods and services, the production and the consumption of which led to pollution. The cost of the measure should not be accompanied by the subsidies as it would lead to distortion in international trade and investment. The polluter pays principle is part of a set of broader principles to guide sustainable development worldwide. The polluter pay principle forms a part of the environmental law of India also. So now we will go to the very background of the development of polluter pays principle. The World Commission on Environment and Degradation on its report, Our Common Future, stated that the cost of repairing the environment can be paid by internationalization of an enterprise. Herein, internationalization in economic context means that the polluter bears in the cost himself and does not delegate the work to an agent. The report mentions that the enterprise should be encouraged to invest in taking preventive, restorative, and compensatory measures. The polluter pays principle was first introduced by the Organization of Economic Cooperation and Development in 1972. The report stated that the polluter is responsible for the controlling and prevention of pollution associated with the process of the manufacturing in factories and industries. Pollutants are soon recognized by the World Commission on Environment and Development as a form of waste. Hence, the pollutants into nature was considered as an inefficiency of industrial production. So, the implementation of polluter pays principle was used as a strong economic, administrative, and legal tool to restrain the pollution problem. So, now we'll discuss the very application of the polluter pay principle. So, in the context of India, as it was applied by the Indian judiciary, so in India, the polluter pays principle was for the first time applied and defined in 1996 in the case Indian Council for Environmental Action versus Union of India. In this case, Justice Dalbir Bhandari determined that reversing the imbalance caused to the ecology is the part and parcel of the industrial process. Thus, the financial responsibility of taking prevention and controlling measures for the pollution cause should rest upon the industry which caused pollution. The financial burden cannot be shifted to the shoulders of the government. Rather, neither in preventing nor in correcting the dent, multiple interlocutory and interim applications were filed in this case after the dismissal of the writ petition, the review petition, and the curative petition by the court. So, Justice Dalvi Bhandari in this case consider that it is easier for men with power and authority to disobey or non comply with the judicial pronouncement. So also in the another important leading case, and that is Andhra Pradesh Pollution Control Board versus Professor M.B. Naidu, retired and others in 1999. The judges further improved the scope of implementation of this principle. The judges enabled the courts, tribunals, and other environmental organizations to apply these principles when cases are registered in the tribunals or organizations. So, Article 21 of the Indian Constitution emphasizes on the basic rights of every Indian inhabitant. The basic right mentioned in Article 21 is right to life and personal liberty. As simple as it can be put, polluting the surroundings of a locality would take away the basic right from the inhabitant. Pollution being the inevitable part of industrialization, community participation, her protection of the environment is a duty of every citizen. Hence, the right to community participation for protection of the environment is considered to flow from Article 21 of the Constitution of India, and also in India, in accordance to Section 20 of National Green Tribunal Act of 2010, the endorsed tribunal can apply for the principles of sustainable development, the polluter pays principle and precautionary principles while passing any order, award, or decision for balanced development without harming the Mother Earth. And now we'll find out the very drawbacks in the principle. So, vehicular emissions are the largest contributor to air pollution. Nearly two-thirds of deaths in 2015, which counts as much as 385,000 deaths, were due to emission from the exhaust of diesel engines. The effluents discharged into the water bodies can be treated. The dumping of waste on soil can be minimized by good management. The treatment of polluted air is an unfeasible task. Moreover, when an entire city or an entire nation is affected by air pollution, it is even more challenging at times such as in cities in northern India, where even the annual rainfall is scarce and the cities are landlocked. Steps taken by the government are never enough to combat air pollution. Air pollution due to the vehicular emission clearly exceeds the air pollution due to industrial emission. Yet the main focus of this lecture is on industrial pollution, as compensation for industrial pollution is primarily emphasized in the polluter pays principle. Is it the owner of the vehicle or the manufacturer who is to be punished for the vehicular emission? Unfortunately, there is no clear mention in the polluter pays principle as to who is to be made liable for the vehicular pollution. So now we will discuss the judgments of certain landmark cases decided by the Supreme Court. So, in that regard, first we will discuss the Indian Council for Annual Legal Action versus Union of India and others in 1996. So, the very facts of the case in case of Indian Council for Annual Legal Action versus Union of India and others are as follows. An environmentalist organization brought into notice the sufferings of the inhabitants of a small village called Bichri in Udaipur district in Rajasthan. An industrial complex primarily involved in manufacturing chemicals was located in the village Bichri. The emission of concentrated sulfuric acid and aluminum sulfate from one of industry, Hindustan Agrochemical Limited, caused discomfort in the lives of the villagers. The effluents from the factory were very difficult to deal with as it was refractory in nature. Many of the chemicals polluted in the soil, polluting the groundwater, and the polluted water even destroyed the standing crop. As a result, the villagers had to bear the brunt of barren agricultural lands. Hence, the judgment was held that, however, engaged in an activity which involves usage of inherently dangerous substance shall be liable to pay for the damages so caused to human and nature. The polluter pays principle was applied by making the polluter responsible for all the financial expenditure in bringing the surroundings back to its original condition. And now we'll discuss another important landmark judgment of Supreme Court, and that is Vellore Citizens Welfare Forum versus Union of India and others in 1996. In this case, the citizens complained that the untreated effluents of tanneries and other industries of Tamil Nadu are discharged into rivers. In the tanneries, about 200 tons of leather were produced each day. Every 1 kilo utilizes 40 liters of water in the process, and every liter of water contained 176 different forms of toxic acids. Such toxic nature of the effluents resulted in contamination of potable lands, potable water due to rain and floods in the nearby town. The river water flowed into the adjoining lands. The lands adjoining were mostly used for cultivation and agricultural purposes. As a result, the agricultural land was contaminated due to the effluents. Hence, in this case, the industrialist ought to take the necessary steps for the restoration of the environment. And the most important leading case that we want to discuss is the Taj trapezium case, which is otherwise popularly known as Taj trapezium case, but in actual it is MC Mehta versus Union of India and others, which was decided in 1997. So, in this case, it was reiterated by the apex court that the polluter pays principle and emphasized the need of application of the principle. The lowing and decaying of the priceless national monument, the Taj Mahal, was a matter of concern in this case. According to report of the National Environment Engineering Report Institute and the Bardarajan Committee in 1999 and 1995 respectively found the foundry's chemical industry and Mathura refineries were the major polluters of the Taj Mahal. The court can order the industries to switch to gas from fuel or shift their location of work. The industries which did not comply with orders, those industries were shut down unconditionally. Justice Kuldeep Singh added a new dimension to the polluter pays principle. He stated that the workers of the industries should suffer as a result of closure or shifting of location. The workers were not to be given compensatory benefits in the form of residential accommodation, continuity of their job till the industry restart, etc. Since then, the courts have time and again have emphasized that their rights and duties of the workers cannot be compromised with. This incident was a watershed in the history of environmental law management, and in that connection now we'll discuss certain important developments and that regarding before the invention of polluter pays principle, one of the most important environmental problem faced by the residents of National Capital Territory of Delhi in the case of Shriram Food and Fertilizer case by leak of oleum gas from the factories, which caused the instant death of an practicing advocate of the Sajari court. So, in that case also, the polluter pays principle was applied, and another most important leading case that we found in the history of environmental pollution in India, and that was Bhopal gas leak case, where the Union Carbide of United States of America, which engaged in India in Bhopal manufacturing everyday batteries. So the very leak from Bhopal gas factory, the most poisonous gas that was methyl isocyanate, which caused thousands and thousands of people being killed. And even till now, most of the affected people are suffering such many incurable diseases. So, the very idea of the government which compel the national government, that is the government of India or the central government which enacted the Public Liability Insurance Act in 1991, so also the central government and the Union Parliament enacted the National Environment Tribunal Act 1995, and accordingly, on the basis of the provision of the National Environment Tribunal Act 1995, the National Green Tribunal, or the NGT, was formed under the National Green Tribunal Act of 2010. So, also in the very Bhopal gas leak, the principle of absolute liability was applied, and before that, the very principle was, as we know, under law taught was the principle of strict liability as it was developed in the leading case. That was in 1868 of Reliance and Fletcher. And that particular principle of strict liability was further enhanced by the Supreme Court of India as principle of absolute liability. And now we'll discuss the very conclusion. Although there is no statutory mandate on the polluter pays principle, nevertheless it takes more effort in compelling people to the principle rather than mandating it. The judicial pronouncement on this principle have been clear, crisp, and undisputable. It was realized that industries are also social units having rights and duties towards their surroundings and the community. The old concept of development hand in hand with ecological balance does not hold good in the 21st century. Yet, ravaging nature in the name of development is no more acceptable. In fact, the lockdown mandated throughout the world during the coronavirus infection is rest to nature. The animals of nature coming to streets during the lockdown in analogous to humans captured in cages and animals on a visit. Over the years, our behavior towards nature has been inhumane. Nature has been put to overwork in the last 2 decades. It is high time for us to care for Mother Nature. So, we have completed the very lecture on this very important document, that is polluter pays principle, in this lecture, as it is an important in connection to the entire world, including the biological spaces also, the geological and zoological spaces all are affected by environmental pollution, climate change, and global warming.